The next item of business is topical questions, and I call Ros McCall.
Thank you, Presiding Officer. To ask the Scottish Government what its response is to the Children and Young People's Commissioner Scotland's call for it to introduce legal protection for children on the use of physical restraint and seclusion in all situations where children are in the care of the state.
Cabinet Secretary Jenny Gilruth.
Restraint and seclusion of a child or young person must only ever be used as a last resort to prevent the risk of injury. A statutory framework already exists in many areas, including children's residential and secure care, for those rare times that restraint or seclusion are necessary. We published new guidance for schools on physical intervention last week, which reaffirms this position and has been drafted in line with our responsibilities relating to the UNCRC 2024 Act. It provides further advice on prevention, training and safeguards in relation to the use of restraint and seclusion. This guidance has been developed carefully with extensive input from key stakeholders, including the Children and Young People's Commissioner Scotland, young people, parents, staff and the teaching trade unions. We will work with partners to monitor and review its effectiveness by autumn 2025. I also recognise there have been calls for further legislation, and we are exploring further options to strengthen the legal framework for schools. This includes my engagement with Daniel Johnson MSP's Members' Bill, which I will consider carefully and respond to accordingly.
Ros McCall.
I thank the Cabinet Secretary for that response. We are now 6 years on from the Safe in Hands report from the Children's Commissioner and 2 years on from the In Safe Hands Yet report from Enable Scotland, which called for statutory guidance on restraint and seclusion in schools to be published. And yet the new non-statutory guidance on restraint in schools is still leaving children at risk, according to teaching unions and the Children and Young People's Commissioner of Scotland. Despite the assurances from the First Minister in response to my question last week and the answer just given by the Cabinet Secretary, the rights of children and young people in Scotland are still not protected, and that's unacceptable. So does the Scottish Government accept that its draft guidance at this stage is simply not good enough?
Cabinet Secretary.
I thank the member for her question. I know she raised the question at First Minister's questions. I heard the response from the First Minister, and of course the member and I will continue, and I'm sure out with the Chamber, to work on the issues that she has raised today. The member spoke about the delay in relation to the new updated guidance, which I accept should have been updated before now. But it is important to say that the advice in relation to that guidance came, of course, from the then Children's Commissioner at that time, and his view on that matter changed, I think, in 2022, and the current Children's Commissioner is echoing the views around the previous Children's Commissioner in relation to the guidance becoming statutory. So the guidance that we have updated is non-statutory, as the member knows, and of course Mr Johnson has a Members' Bill, which I am very aware of, and of course have committed to and have been working with him throughout the course of the past year. It's also worthwhile saying, though, that the member mentions views of the teaching trade unions. The teaching trade unions were, of course, represented on the physical intervention working group, so the guidance has been developed very carefully over time with extensive input from over 30 different groups. That includes the Children and Young People's Commissioner, young people, parents, staff, local government, teaching unions, including the NSUWT and those calling for Callum's Law. So I think it is worthwhile saying that this is a piece of work that's been taken forward by a range of different partners. I recognise the call for further action in this space. I'm committing the Government to working with members across the Chamber to that end and to exploring further legislative options. But I do think it worthwhile saying that this updated guidance is a move forward, and whilst there have been delays, it has been broadly welcomed across the sector, and I commit again, Presiding Officer, to working with any MSP, from irrespective of party, to ensure that we have legislation and support that is fit for purpose and that supports our children and young people in their education.
Ros McCall.
Again, I thank the Cabinet Secretary for that response, and I am happy to work with the Cabinet Secretary on this. But I fear that the words of the Children and Young People's Commissioner is not fully being taken into consideration when they state that we have moved well beyond a position where putting the guidance into statute should be more than just an option for future consideration. I mentioned the case of Isaac Talker, which I raised with the First Minister last week. It's yet another instance of children being restrained, sometimes to significant injury to themselves, and placed in seclusion. Now, the First Minister reiterated to me on that occasion that he could foresee no circumstances in which what happened to Isaac should happen. However, the fact is it did happen, and it's one of many cases. And experts are saying that new guidance is simply not sufficient to keep all our children safe. So is the Cabinet Secretary confident to guarantee that every child in state care today is safe from unnecessary restraint and seclusion, given the Scottish Government's new framework that's just been released?
Cabinet Secretary.
Well, I thank the member for her question, and as she's aware, I heard the response from the First Minister, and I very much share the serious concerns that she has raised in the Chamber last week at First Minister's questions and again today. And I echo very much so the words of the First Minister, who said there are no conceivable circumstances which would justify the treatment of your constituent within the guidance provided to schools on restraint and seclusion. So I again put that on the record that I agree very much with the First Minister's views in that regard. I think, Presiding Officer, this comes back to the safety and well-being of our children and young people in schools, and that is absolutely paramount. So restraint and seclusion must only ever be used as a last resort to prevent the risk of injury. And the Government, of course, supports the intention behind Daniel Johnson's proposal, and I'll continue to work with him as his bill progresses. And just because we have updated the guidance does not preclude, of course, the Government from working Mr Johnson on his bill. The member's bill process is at an early stage, but I will consider the contents carefully and work, of course, and respond to the member in relation to his work. I think it's important to say too, the member queries the effectiveness of the guidance itself, that there has been a clear commitment given that the guidance will be updated within the year, and we will respond to and will monitor the progress and development of the guidance throughout the year to ensure it is being used effectively. But I hope the member hears the tone and the spirit in the way that I am engaging with the question today, that the Government will work with members across the Chamber. It's really important we get this right. I know there are a range of different stakeholders who have different views in relation to the guidance. I think it's fair to say we heard some of those on Friday at the publication of the updated guidance. But I do think it's also worthwhile recounting, Presiding Officer, that Beth Morrison, of course, who has been leading some of the work on Callum's Law, who said that today is a positive step for children in Scotland. That was her response last Friday. She also recognises there is more to be done, and I commit to working with MSPs across the Chamber to do exactly that.
Bill Kidd.
Thanks, Presiding Officer. I understand that preventative support and early intervention is one of the Cabinet Secretary's top priorities, with a focus on improving relationships, behaviour and attendance in schools. Can the Cabinet Secretary therefore please speak to the most recent guidance published in the Behaviour and Relationship in Schools Action Plan, and how the Scottish Government is following up on its implementation and success in schools across Scotland, please?
Cabinet Secretary.
So the new guidance which we published last week on Friday on the use of physical intervention in schools is the latest part of the delivery of our Relationships and Behaviour Action Plan, which I launched at the end of the summer. And as Bill Kidd points out, the guidance advises that prevention and early intervention must be our primary approach. This means that we want to address the underlying causes of any behaviour that poses a risk to the safety and well-being of others. And the approach will really help teachers and school staff to deliver a safe and supportive learning environment and prevent the need for restraint and seclusion. And I was quite taken, Presiding Officer, with some of the views expressed by the EIS on this, who talked about some teachers feeling that they lacked confidence in relation to the current policy. So we very much hope that the updated guidance will help to provide support in that regard. Local authorities also have an important role to play in supporting staff to implement the guidance, and I therefore welcome COSLA's statement last week that the new national guidance will enable local policies and practice to be reviewed and updated. And of course the Scottish Government will work with our partners to monitor and review the effectiveness of the guidance by autumn 2025, as I previously intimated.
Thank you. Daniel Johnson.
Thank you, Presiding Officer. Can I thank Ros McCall for tabling this question? I think the guidance does take us forward. We have clear definitions. I think the requirement to inform parents within the school day or at the outside 24 hours, and the comprehensive recording are all important. But in 2018, in the Children's Commission report No Safe Space, it found 2,674 instances of restraint against 386 children. But most concerningly, only 18 out of 32 local authorities were recording, and less than half in total were recording comprehensively. Is that not why we need this guidance on a statutory basis, so that councils and local authorities have to record and inform, because parents are not being informed in a timely manner, and critically, there is a gap in the recording. And so what steps will the Government take to ensure that all of these instances are recorded by education authorities?
Secretary.
I think Mr Johnson raises a really important point, and obviously want to recognise the work he's undertaking on this really important issue. And actually, reflecting on some of the commentary from the NASUWT on Friday, they raised the very point that Mr Johnson's raising around about inconsistencies of approaches being taken by local authorities. And of course, it's really important that local authorities have an important role in supporting their staff to implementing the new guidance and also to updating their local policies. But the new guidance does include advice on reporting, recording and monitoring restraint and seclusion to ensure we can have a more consistent approach across the piece. That guidance applies to all schools whether they be local authority, independent or grant aided. But I recognise the issue the member raises, and of course I look forward to working with him throughout the work that he's taking forward in relation to his member's bill. But I hope he does recognise and acknowledge that the new guidance does make specific reference to the issues he has raised today because of the challenge in relation to that inconsistency across the piece.
Willie Rennie.
I do support putting the guidance on a statutory footing, but isn't this whole debate a result of a failure of the rest of the system? That we're focused on the last resort means that the other resorts are actually not effective. We've got significant problems with behaviour and violence within schools, also distress, and actually a failure to support and additional support needs. So shouldn't we be redoubling our focus on trying to resolve those issues so we can narrow down to the greatest possible extent the use of restraint at all?
Cabinet Secretary.
I mean, I agree with the premise of Mr Rennie's question, and I think post-pandemic in particular, some of the challenges he talks to in relation to ASN and changed behaviour in our schools are very live issues to me as Cabinet Secretary. It's I spend a lot of time in the Chamber responding to challenge on that very point, but I also think in government we need to reflect how we can better support local authorities on these issues, because post-pandemic things are different. I was actually in an ELC facility in Mr Rennie's constituency very recently in Balmullo, and I was listening to what the ELC practitioners were doing with that local authority to respond to delays in speech and language and communication post-pandemic. So it's important that we can work with local authorities to respond to that greater need post-pandemic. And I think we too in government have to respond to how we can better resource and support that. It is worthwhile saying, Presiding Officer, that in the last financial year we have spent record amounts on ASN. We've seen an increase in learning support assistance by 725, which is welcome news. But I accept that's not the end of the story. And I suppose the premise of Mr Rennie's question is that this issue relates to wider issues within our education system post-pandemic, which I would agree with. And of course, the government is in listening mode. We are approaching the budget. And if Mr Rennie has any proposals to that end, I'm sure that my colleagues and I will be happy to engage with him on those issues, because we are all, I think, singing from the same hymn sheet in regard to this issue. We want to improve the support that's available for our children and young people.
And Martin Whitfield.
I'm very grateful, Presiding Officer. My apologies to the Cabinet Secretary because I'm going to amend my question to her, because I would like to go back to Ros McCall's third question. The Government have talked about review and update. The local authorities have talked about review and update. The Government are going to review this in autumn 2025. So when will all children be safe following this guidance?
Cabinet Secretary.
Well, look, I think it's really worthwhile saying, Presiding Officer, the guidance has been drafted in line with our responsibilities relating to the UNCRC 2024 Act. It does give advice to staff on prevention, training and safeguards in relation to the use of restraint and seclusion. And, of course, it advises on types of restraint that should never be used on children and young people, and that is really important. The member asked a challenging question in relation to the use of restraint in schools, and I know that in the coming weeks we will go on to have discussions around about Mr Johnson's bill, so I commit to working with him on that issue. I've heard the challenge today, and I'm very aware of the inconsistent approach at the current time that's used by local authorities across the country. I do go back to the purpose behind this guidance, which is about providing a more consistent approach across the country. And I commit to working with COSLA and with members across the Chamber on how we can deliver that and ensure that our children and young people are safe in school.
Thank you. That concludes topical questions. I'll allow a moment or two for front benches to organise for the next item.